Hello, everybody. Let's get ourselves started to today. We are 29 people. I know you guys have other things due this week, which may mean a trickling number of people will join us later and or will not. But in any case, all I need is you, so it's fine. So today we are starting to look at other doctrines of um, contract law, other things that are needed other than offer and acceptance to create a validly enforceable contract. And for today, we have on call Jay Ali. I'm not sure if I saw Jay. Yeah, there you are. Stephanie, Elena. I think I just saw Laheen. There you are. Tyler and Kyle. So everybody is here. Before we go on, I just want to say, I know it's a busy time of year. I know, you're at that point where you're just exhausted, but still you must go on. I remember this feeling vividly. I sort of kind of feel the same way, to be honest. But I will have a reading week and you guys will not. However, mostly people really enjoy WLPS because it's this moment to think about how we use principles that we learn in class and in everyday relationships and to figure out oh, how do I interview a client in a way that just extracts the legal information I need without just being an automaton who ignores all of the emotions that are, this person is dealing with. And how do I negotiate on the basis of knowing this is what the courts would do, etc. So it starts to bring to life a little bit what we've been learning. I'm going to tell you something unhappy, and I'm real sorry to do it, but I do it with love, which is that after the end of the reading week, exam studying has to start happening for reals. I'm sorry. I don't bring this news with joy, but I think, and I know you're overwhelmed, and I know there's a lot going on, but I also know you guys have been working steadily along the way, and so you aren't starting from scratch, I think, for most people, and even if you are, lots of time, but it's not like undergrad, and I'm not making this up, where you can just 2 weeks beforehand, 1 week beforehand, rock up and try and figure it out. This goes badly. I'm going to post a couple of other hypos, bigger hypos from old exams, and you're welcome to work on them and come back and get some feedback, or any of the smaller ones we already did. I know there may not be time right now to do that, but I'm just putting all the opportunities out in case you can make use of them. I'm not going to have office hours next week because, reading week also, you guys will be doing stuff during reading week time. But if it's needed, I'll make longer hours when we come back to class after that, so I can be of use to people. Okay, so yeah, I do want to communicate through the computer screen that I feel, I send you guys energy as I don't have much to spare, but I send it all to you guys, and you can do it. Generations of people have. Does it make it less fun? But if you're actually, people are dealing with real live things, and if you are, and if I can help you, then get in touch. Okay, the end. Okay, so today we're going to start in on looking at the two other things that are needed to create a validly enforceable contract. And the first is certainty of terms, and the second is consideration. And we'll spend some time, a few weeks, on consideration. Excuse me, because we're going to look at consideration, what is needed to create a contract, but we're also going to look at when and to what extent consideration is needed to change the terms of a contract. And then that will lead us towards the end of the semester. So way back at the beginning of the semester, which is now a long time ago, I mentioned that there are a number of different concepts that have to be established to create a legally enforceable contract. So we know offer and acceptance is the first. If there's no offer that's properly accepted, well, there's nowhere to look at to determine whether there's been any consideration exchange. There's nowhere to find the terms to figure out if they're certain, etc. So offer and acceptance has to go first, right? But then the person arguing that a contract has been established would also need to show that there was certainty of terms, which we'll talk about today, and consideration. There are two other things that arise in some cases, but not always. Intention to create legal relations. That issue is about contracts between family members and friends. Situations where you look like, the facts that would look like there's everything you need for offer and acceptance consideration, but it really wasn't intended to be a real contract, right? So I had this example that I found a few years ago about like someone who went on an online date and then tried to argue that it created like a validly binding contract that the woman would go out on another date with him because he paid for the meal. Even if you can come up with your offer acceptance and consideration and certainty of terms, nobody thought that was a contract, right? You didn't even think that was a contract. In fact, there's some sexist issues to be dealt with in this potential contract, right? So intention to create legal relations, unfortunately, we won't have time to cover. But the idea is that sometimes with family contracts, they're not presumed to be enforceable. And so you have to go, even though you have everything else, you have to show something additional. Again, we're not going to go through that one. Also, there's a statute called the Statute of Frauds. It used to be that lots of contracts, most contracts had to be in writing for evidentiary reasons. But as we know now, most contracts don't have to be in writing. But the statute of fraud still requires land contracts and insurance contracts to be in writing to be enforceable. Again, I'm not testing you on that, but now you know. Finally, there's an area of law about capacity to contract with minors, contracts with people who the courts deem don't have capacity to make informed decisions, etc. It's a very interesting and difficult area of law, but unfortunately we don't have time to get into it. So we're just going to be doing certainty and consideration in addition to offer and acceptance. Those are the ones that will always come up. Okay. So the idea of certainty of terms is that when an offer is properly accepted, that offer must contain all the essential terms of the contract. It doesn't have to contain every term. It can have some details that the parties are still going to work out, but it has to contain all essential terms. And we'll talk in a few minutes about what constitutes an essential term. So the concept of certainty of terms specifies that a contract must contain all essential terms, and those terms must be capable of being given meaning. We have to be able to figure out what they mean, what the parties actually agree to. Okay. And the whole concept of certainty of terms relates once again to that idea of consensus ad idem and a meeting of the minds. Now, I've mentioned before that, and just a reminder, the concept of the meeting of the minds, it's not a standalone legal principle. So you don't go to court and say there was no meeting of the minds because here's some facts and walk out, right? The idea of the meeting of the minds is demonstrated through the principles of offer and acceptance, right? When there is acceptance, then we know that the parties have agreed on mirrored terms. So each party's agreed to the exact same thing, right? And so the way the rules of offer and acceptance are designed is to lead us to a demonstration that consensus exists. This is the same thing with certainty of terms. The idea is that the rules around certainty of terms are designed to demonstrate, again, that the parties have reached a meeting of the minds. And the idea is if you created an agreement, right, there was offer and acceptance, but the offer that was accepted didn't explain what it was the parties have to do, or it was ambiguous in the way it was described, what the parties have to do. If it's a purchase contract, what they have to pay, when they're supposed to perform. How do we know when the contract's breached? And if you haven't come to agreement on these really central terms, how can we say you've actually agreed to the same thing? You don't even know what you're supposed to do, right? And so if you haven't come to agreement, you haven't included all the essential terms, or they're too vague to be given meaning, do you actually both know what you're supposed to be doing? Probably not. In which case we say there's the contract is too uncertain to be enforced. So at the broadest level, what we're looking for when we're talking about certainty of terms is to say, to an objective bystander, does it seem like the parties intended to contract and all of the essential terms have been given enough meaning to be determined with a reasonable degree of certainty? Now, this isn't the test you use very directly to figure out whether certainty is there or not. It's like the big idea of certainty of terms. Okay. Now, I'm going to talk about the two different types of certainty. And then after that, I will talk about what constitutes an essential term. Any questions so far? So the first kind of uncertainty issue is the issue of incompleteness or missing terms. So the idea here is the contract missing an essential term on its face? When you look at what's there, is there an essential term missing? Okay. That's when you have an incompleteness issue. So if you have a contract for purchase and sale and there's no price, the price is just missing, then you're dealing with an issue of incomplete terms. The vagueness issue arises where an agreement is complete on its face. It has all the essential elements, but the way they're expressed is sufficiently ambiguous that it's not possible to figure out what have the parties actually come to an agreement about. Now, to put this in a little bit of context, there's two issues when it comes to interpreting the meaning of terms in the contract. One is a vagueness issue, a question of has this contract been properly created? If the terms that you've agreed to are super vague, can we say that you actually agreed to the same thing such that a contract was formed? But once a contract is formed, because all the essential terms are sufficiently clear, the parties may go on to disagree about the meaning of some of the other terms. And that's not an issue of whether the contract was properly formed, but what are we going to say is the actual interpretation we should give for any one of these things? And that's a question that arises after the contract has been formed and when we're trying to figure out if a contract has been breached. We'll get to that next semester. Okay, at this point, the question is, again, can we even figure out what you guys agreed to such that we can say you've reached a meeting of the minds? So if I say to you, and we have an employment contract, and we agree that you will work weekends if there's an emergency arises. What is the problem here? Fahim?
It doesn't specify what an emergency is.
Yeah, how are we going to figure out when an emergency arises? Is it when I decide it's an emergency? Do we have some explanation, definition, criteria by which we can figure out what emergency means? If not, well, have we really reached a meeting of the minds on this question? If this is an essential term of the contract and we haven't, the contract would fail. If it's not an essential term, then it would be dealt with after the contract was formed. Okay. With missing terms, for instance, if we have a contract that says the goods that I'm purchasing from you will be transported by train, but it doesn't say anywhere who's going to pay for the transport on the train. or the train, the cost of the train transport. Well, in lots of contracts, that could be an essential term, right? Because that could significantly impact on each party's costs. And so if we don't specify in there who's going to pay for it, how are we supposed to figure out what each party has agreed to? And how are we supposed to figure out when they've breached it? And how are we supposed to figure out what losses could flow from the failure of a party to undertake this obligation? So the missing terms, again, is where a contract is incomplete on its face. And vagueness is where there's something there, but it's not clearly expressed. Now, although I make this distinction, in practice, the rules are effectively the same. Some of the rules will get a bit more application with one issue than the other, but the rules are the same. And you'll see sometimes, you know, the line between a missing term and a vague term is a bit unclear. And that's okay, because the rules are effectively the same. Stephanie?
Sorry, just going back to the vagueness example for a second, could it also be considered vague that they use the term you? So like depending on who it addresses in the situation, maybe there's like two parties involved and it doesn't really clarify if it's for both or for one of them.
Yeah, like, I mean, it can depend on the contract. Usually if you have a written contract, it would say like the party to this agreement is X and Y with your name, and then it would say the parties agree that name Y would. So you wouldn't usually express it in writing this way. And if we were just speaking to each other, then it probably would be clear. But yes, in some contexts that could be vague.
Thank you.
Okay. So the idea is if you've got a term, so the tension involved with missing and vague terms is sometimes the contracts will have been performing a contract for some time, but actually, and then one party will say, no, I'm not doing it anymore. And when they're sued for breach, they say this contract was never properly formed. It was too uncertain. Well, in that kind of situation, if the court agrees that the contract was too uncertain, then that whole, whatever years of performance goes away. Everybody has to give their stuff back. That contract was never properly formed, right? And that can just be, as we'll see through some of the examples, a way in which one party is just trying to breach and get away from it, get away with it. On the other hand, so the courts say, if there's a term that's missing or vague, we should look to the rest of the contract to see if we can find meaning. Can we clarify the vague term, or can we figure out what the parties actually intended for the missing term from the rest of their agreement? If we can, then we should give that the meaning, and there's no certainty problem, right? So if we can look at the rest of the contract and figure out what an emergency is supposed to mean, because it's discussed in different ways in different places, then we can give meaning to emergency and no certainty problem will arise. But the courts cannot make a contract for the parties. And so if you can't find meaning for the rest of the contract, then the courts can't step in and fix the problem. Okay, they can't just be like, well, okay, I'm going to say this is the price, or this is what emergency means. So this is the tension. And you'll see in the two cases we have a little bit contradictory in the sense that the facts are very similar in these two situations, but the courts in each one use some of the principles more stringently than others. And so this is an area of law where theoretically the principles are clear, but in any given situation, this tension can be quite significant and you don't really know which side the court will fall on. And so it's an area of law that is itself uncertain. Sorry, no pun intended. But you have these two cases which give either party a series of arguments they can make in support of their position. So this is one of these areas where one party says contract too uncertain. Look, Maine Butcher. And the other one says contract sufficiently certain, can find meaning. Look, Hillas, right? And so each party has a case to kind of deploy against the other when they're making arguments on this issue. And there's also kind of material to analogize and distinguish from. Now, to clarify, a contract that is uncertain, where the essential terms aren't sufficiently certain, is void. When we say it fails for uncertainty, it means there's no contract. The whole contract is gone, and it was never created in law. That's what void means. You'll see it sometimes discussions of contracts that are voidable. That's a different concept. That's when there's a problem with this contract, but one party can choose to ignore it and keep going with it, or they can choose to void. But if a contract is void, there's no choice. There was never any contract. It never existed. Everybody give your stuff back. Okay. Questions about this? If there is a non-essential term that's too vague or incomplete, that term can be severed from the contract and the rest of the contract persists, but only if the term is non-essential. Okay. Okay. What is an essential term? So obviously, because that would be easy, there is no list of what is an essential term, right? We don't have like this kind of term is essential. And as the court tells us in Viscount Deneenan tells us in Maine Butcher, and the court in Canada told us in Mitsui, which is in the case excerpts that I gave you, what constitutes an essential term varies based on the nature of the contract. And this makes sense because what is needed to make one type of deal operational is not necessarily needed to make another type of contract operational. Okay. Like if I'm not paying for something in money, then I don't need there to be a price in my contract, right? If the contract is for something that doesn't require delivery, then time of delivery is not an essential term. But if it's really key to the deal that we know when deliveries will occur, then it can be. We don't have a precise definition. You know, I've spent a lot of time this weekend being like, could somebody just like give me a succinct definition? Because I know what it is, but why can't I have a citation for my explanation of what is an essential term? Nope. It's one of those that everyone just operates on the basis that we all know what it means and they don't define it. But when you look at the different analyses of what constitutes an essential term, it is a term that helps the courts figure out what are the primary obligations of each party. The term is essential if you need it to be able to figure out if one of the parties is in breach. If a term is missing or uncertain, and without that, the court can't tell if anyone's in breach, you can't tell what each party is supposed to do, that's an essential term. In the same way that if either there's a term missing or uncertain that is needed for the court to be able to figure out what losses would flow from a breach, then that's an essential term. So if you were supposed to buy something from me every month for the next 3 years and there's no price, and then you stop doing it, how are we supposed to figure out what I would have gotten for the next 3 years to figure out what is my losses, right? So an essential term is a term that is needed for the courts to be able to figure out, and for the parties to be able to figure out what are their obligations so that they can know if they are in breach, and so that we could figure out what losses could flow if they are in breach. Okay. And so when you're trying to ascertain, is this an essential term? You're looking to the nature of the deal. Without this term, do the parties, they know the main things they're supposed to do under this deal? Do the parties know when they're in breach? Could they figure out the losses if there was a breach? That's the question you ask yourself to determine whether something is an essential term or not. Isabella?
Hi. So I'm kind of struggling with the concept of saying that in order for it to be an essential term, it needs to be like you need to be able to figure out if it's a breach. But what if isn't it possible to breach a non-essential term as well?
Yes, but then the main part of the deal would still be operational. If you're breaching a non-essential term, you haven't gutted the deal.
Okay, so then I guess what I was asking is like if a plaintiff is trying to sue someone for breaching a non-essential term, then this isn't something that we would be discussing. Am I right?
Yep.
Okay, thank you.
Because the contract would already be formed. So now you'd just be figuring out what was required. Does that make sense?
Yes, it does. Thank you.
Other questions here? Okay. So the courts say that they cannot, that there is this tension, right? Why, or I'll come back to this in a second. Never mind, bracket that sentence. So sometimes the parties just forget to address something really significant, or it's drafted badly. It's hard to think when you're drafting. It's hard to think about every eventuality that could arise. I mean, that's what you're trying to do. And then you're also trying to write it in a way that covers all potential eventualities and isn't like 1 trillion pages long, right? This is the art of being a contract drafter, but it's not easy to meet that. And so things will arise that you didn't plan for, a situation not covered, etc. But sometimes the issue isn't that a mistake was made. The issue is that the parties want to bind themselves now. They want to create an enforceable contract, but they want some pieces of that contract, the terms of it, to be determined at a later date. So if this is a contract for a good or service where the prices fluctuate a lot, maybe the parties want to agree that the price will be what's the market value at the time that they're going to exchange it. Maybe they don't want to set it now, right? They want to see how things will change. Or like, as we all know, the supply chain's super backed up. There's all these shipping delays. If part of your contract is shipping something, you might want to find out, what are the actual situations, because they're changing so much at the close to the time of shipping, to figure out like what kind of guarantees could be provided about when it's going to arrive, what happens if it doesn't arrive, etc. So then the challenge is, how do you create a contract that is currently enforceable? It has sufficient terms to be enforced, but it allows for certain aspects of the contract to be precisely defined in the future, right? This is a challenge. How do you cover the certainty of terms issue and ensure that all the essential terms are there if you don't want to bind yourself to super specifics at the onset of your relationship? So there are 2 main ways in which parties do this, okay? And when it works, awesome, but sometimes it doesn't work. And then we have lots of things to debate on certainty of terms if we litigate it. So one of the most common ways of addressing this problem is including a formula in your contract about how the term will be determined, the content of the term will be figured out at that later date. So we would create criteria, right? So maybe we would say we're not fixing the price now, but the price will be fair market value on September 25th, okay? So in that context, although we haven't said what the price is, we've stipulated a way in which the price will be determined in the future. And so we've created a formula. And so long as we can figure out what is the fair market value on the given date, then that's fine. That works, right? Because there are objective criteria based on kind of things happening beyond the control of the 2 parties that can be used to determine the content of the term that you want to leave open. This can be all sorts of things. It could be delivery will be based on the average delivery times in the 4 weeks preceding X date, right? So long as we can figure out, who's included in the average, etc. That all works. Okay. The problem that arises is when your formula doesn't work. So if you create a contract, you leave something undefined, but you define from the outset how the content of that term will be determined in the future, that's fine, right? You've included a formula, the formula is sufficiently certain so we know now how that term will be determined later, and there's no certainty issue, okay? The other thing that people do is they'll appoint machinery or a mechanism. And what we mean here is they'll appoint somebody or some process or institution to decide the content of the term. So they're not specifying how we'll figure out the term, they're specifying who will figure out the term. They've given that power over to somebody else. Of course, confusingly, sometimes they do both. Here's the formula, and here's the person who will apply it. Okay? So the idea of a mechanism or machinery is that the power to decide the term is appointed to someone else. And again, so long as that person or process is capable of doing it, there's no problem, sufficiently certain, they choose the content of the term, on everybody goes, right? If there's a problem with the machinery or mechanism, and they aren't able to determine the content, now we've got a certainty problem. So sometimes you'll see these clauses, and actually, I can't remember one of these cases, or maybe it's another of the big ones in certainty, has a situation where it was like the parties will agree on an arbitrator, but the parties could not agree on an arbitrator, right? Or we will appoint from this list, and then nobody from the list is available, So there can be situations where you create a mechanism or machinery, but it doesn't work, and then you've got a problem. Okay, questions about this so far? Lahi?
Just as a sort of side question, I was wondering if they can't come to an agreement on the mechanism, what ends up happening with that?
At the time of contract, or at the time that the issue has to be dealt with?
At the time the issue has to be dealt with.
Yes, then one party says, oh, we have no contract, and the other party says, you are in breach of contract, and then they go to court, and then that's how we end up with these cases that we deal with certainty. Yeah. So we'll learn those principles about how this is worked out in the next little bit. Elena?
I had a similar question. I don't know if it falls in the same vein, but let's say the parties appoint an arbitrator and that person like unexpectedly becomes ill, they can no longer do it, but both parties still want to be bound, but they haven't, let's say, set a price, which is very determinative of the contract. Are they able to meet together to appoint someone else, even though the contract clearly states that this person needs to do it?
The parties can always change their contract, and they can always they can decide, hey, you know what, that provision says that, but we're not going to do that. The problem is only if one person then recants, now we've got a problem, because the contract said this, so that sets my kind of original rights. So if you guys want, if you can figure out your price, you're like, yeah, and most of the time that's what people will do, right? In long-term business relationships, they'll figure out, okay, here's another arbitrator, it's fine. And if that happens, there's no problem. There's nothing for them to litigate. There's lots of ways, in fact, the most common ways that people deal with disputes in contracts, they just figure it out, right? They're like, what's the best way? Because they want their relationship to keep going. They want things to work well. It just costs needless money to bring in lawyers unnecessarily. The problem is when they can't agree, and what happens. Jay?
Is there a limit to how many essential terms or provisions you can leave up to be determined at a later date in the contract? Or is there some sort of, like you can, as long as you lay it out properly, it's up to you?
Yeah, I mean, as long as you lay it out properly, and they all, the problem is that the more of them you have, the more likely your formula or your machinery is going to break down. Because again, it's hard to write these things sometimes in a way that catches every permutation. It could happen. It's a good question. Like, it could happen. The court is like, what have you actually bound yourself to? But if you have a formula for each one of them, then that means you've sat down and you guys have figured out together how you want each one of these terms to be figured out in the future. So as long as those work, like there shouldn't be an issue. Does that answer the question?
Yeah, thank you.
Kyle?
Kind of sort of off topic, but kind of deals with the same issue. Is in one of the readings, it mentioned that the term was left open to one of the parties to decide on the price. I was just thinking about it, like, why would they do that in situations? Like, wouldn't one person just be like, oh, I'm gonna buy your house then for $5, and they'd have to agree to it? Like, I was just kind of confused.
Like that's not often going to be a great business move. But the thing is, like we don't necessarily see this on the top of all of these decisions, but it's all about power, right? When Roger says you're going to have to pay $1 million to get a cell phone, I'm like, I'm going to have to pay $1 million to get a cell phone. So people will agree to things because the other party has the power to set the terms. And if they agree to them, they agree to them, is the court's idea. So we'll see when we talk about consideration, like the court doesn't look at whether it's fair, just did you agree to it? Now it's not gonna, and a lot of the time, it's not gonna make any sense to do that. Maybe it's not price, right? Maybe it's like one party is given the right to determine at what date X thing happens, right? And they're more invested than the other party, etc. So there can be lots of different permutations of it. But if you look at this, if we say a contract says the price is to be determined by the parties, which is what you see more often. What is the mechanism here? So there's no formula, right? Because it doesn't say how we're going to fix the price, but what is the mechanism that the parties have appointed here? I know, Tyler, you still have your hand up, so it's okay for a previous question. Jay, I'm assuming that's an old hand. But before I get to Tyler, anyone want to tell me what is the mechanism appointed here? Elena?
Can you hear me?
Yeah.
Sorry, my computer did this weird glitch thing when I hit mute. I believe the parties themselves will determine the price at a later date. They haven't decided what it from the written contract. We don't know when.
Right, so they're the mechanism.
Yes, the two parties that have agreed.
This is not a great plan because if you do not agree, what happens? Your mechanism fails, right? And so we'll see in May and Butcher beyond how does the court deal with that. Tyler?
Hi, yeah, so I know you said that the parties can change the terms themselves. So going back off Elena's point that if like an arbitrator does get ill or they just can't, I guess, arbitrate the case or what have you, are the parties able to change the term of taking out that mechanism and then deciding on the price for themselves? So for example, if they agree with each other that like, hey, we don't need an arbitrator, we'll just do it ourselves. Is the fact that the arbitrator is already the mechanism in the contract, like can they change that term as well?
So there's two parts to the answer to that question. The first is we'll see later in this semester that to change the terms of the contract is not, if the parties can do it, but they have to give each other new consideration. So both parties need to get something. So it's not just like, hey, we're changing it. But the thing is, in practice, you can do whatever they want to do. They can just decide to do something different than the terms of the contract. That's not a problem. But the problem is if they decide to do something different, one party reneges and the contract isn't officially changed, then the terms of the official contract would still remain. Does that answer the question?
Yes, absolutely. Thank you.
No problem. Okay, other thoughts or questions before we move into the case law? So before we get there, no, I'll do it. Never mind. I can't decide on my own pace today, guys. Apologies. Okay, so we start with May and Butcher, and I assigned the version that I posted rather than the one in the casebook because the one that I posted includes the decision not of Lord Viscount, which I don't know that much about, fancy Englishness, but I'm pretty sure that's contradictory in some ways. It's Viscount Dunedin. So he gives us some general principles and some explanations that are quite useful. And then Lord Buckmaster gives us the analysis. So in May and Butcher, what happens is after the First World War, there was this disposal board, so that an arm of the government, and it entered into an agreement with May and Butcher that May and Butcher would buy all of the surplus tents that were left over after the war, for 1921. And it said that the price to be paid and the frequency of payments would be determined from time to time between the parties. And then it also stipulated in Article 4 that disputes arising or referencing from the agreement would be decided on by an arbitrator. In 1922, the parties agreed to conclude a new contract on the same terms, but midway through the year, they got into a dispute, and the disposal board said there's no contract. So who's suing whom for what in this situation? People who are on call who haven't spoken a lot yet. Tyler?
Yeah, so I believe like May and Butcher is suing the disposal board
Yeah.
for what they consider to be breach of like their previously agreed upon terms.
Yeah, so they're saying we had a contract from 1922 and disposal board, you're breaching it. And the disposal board is saying we never had a contract because the terms are too uncertain. What is the main term that they're arguing is missing? Tyler?
I believe it was the price that they agreed upon for the tents.
Yes, and so what does it actually say about what is the price? Kyle?
If my memory serves correctly, it's to be decided by the parties at a later date.
Yeah, it said the frequency and the amount would be decided by the parties from time to time. So the disposal board says, okay, well, there was no price determined, and so the contract fails. Now, Viscount Dunedin tells us that he gives us sort of the citation for some of the principles I've already discussed. He says all essential terms of a contract must be settled for an enforceable agreement to arise, and that what it constitutes an essential term may vary according to the particular contract under consideration. But he tells us when the contract is one for purchase and sale, a price is always an essential term. So at least you know one thing that's always an essential term when the contract is for purchase and sale. He also tells us that even though this case is about a missing price term, the principles they discuss apply more generally to missing terms. So there may be some bits here that are specific to price, but the rest of the principles can be used to make arguments about other types of missing terms. Now, we said before that one of the reasons that the courts have a difficult time when it comes to certainty of terms is that the courts can't create a contract for the parties. And in his reasons, Justice or Dunedin, whatever his name is, Viscount Dunedin tells us why. So why can't the courts create a contract for the parties? Why can't they step in? If the parties have like missed a term or not expressed things well, why can't the court fix it? Jay?
So I think they're not allowed to step in because it's a principle of a long time that if the essential terms aren't settled, that it can't move forward. And it isn't up to the court to intervene at that stage, as I've understood it.
That's right. But the question is why? Why isn't it up to the courts to intervene at that point? What underlying legal principles provokes this rule?
The sale of goods act. Oh, sorry.
yeah, no, it's not, but what, yes, sort of the Sale of Goods Act, but what principle kind of created the concept in the Sale of Goods Act? Isabella?
My understanding is that the whole point of contract law is to allow individuals to get together, agree on terms they like, and get into that contractual relationship together. So if the court takes over and makes these decisions, then what could happen is that both parties are in a situation where neither of them wanted to be in the first place.
That's right, right? The idea is that the courts are supposed to just be interpreting and applying the terms the parties have chosen for themselves. And they say they have no other role. Now, I must say, it's hard to believe because we can see them making all sorts of choices all over the place, but that's what they say. And that idea is really central to contract law and the way we've constructed what contract law is, because it's about individual personal choice, and that's about individual freedom from the state, right? And so I've said a number of times that these ideas of contract law, they are based on creating a certain vision of the market and the role of the state and of individuals, right? The state doesn't make your contract for you. It doesn't force you. You guys choose the terms on which you want to be bound for your, by yourself. So if the courts come in and they change the terms of your contract, well, then you're in a contract that you didn't necessarily agree to, right? And that's not fair, and that's not what contract does. Now, of course, it's, again, I think pretty obvious that like the courts make decisions all the time that changes the nature of the obligations towards the parties. But if they can't keep saying this to themselves, then they'd be stepping away very far from at least the veneer of the way a liberal market-based system is operating, right? The market is about individual transactions between parties who choose relationships to each other. If not, it's not freedom. I do not actually agree with this analysis, in case that's not clear, but that is the idea, right? And so that is what is organizing the principles. Again, this is an instance where underlying ideas of contract law are animated how the rules are put together. So the courts say, if you guys miss something super important, or you didn't explain it well, or you made a formula that didn't work, or you made pointed a machinery that didn't work, we can't fix it for you because we'd be changing your intent. If you say it's going to be determined from time to time by the parties, you say that means you guys wanted to decide. So now if we decide for you, we're changing what you intended. Okay. How does this look like in the actual application? So Lord Buckmaster says, okay, the buyers make two arguments. They say if the price was not specified in the contract, then the price should be a reasonable price. And if it's not a reasonable price, well, that's okay, because they appointed an arbitrator, and the arbitrator can figure out what is the price. Okay. And so the court takes each of these arguments in turn. And I'll go over the argument for the first one. This is like not, the intricacies of it are maybe not super visible. And then we can talk about the second one. So Lord Buckmaster refers to the Sale of Goods Act. And the Sale of Goods Act, he says, are the same as the old principles. And what that means is a codification of the common law. We've taken common law principles and we've put them into statute. And the impact of that is that the courts can't change those principles. If it had just been in the common law, they could decide to change it. But because it's by statute, only the government could change it, so they can't change it. So the principles are the same at common law and under the Sale of Goods Act. And we have the exact same language in our Sale of Goods Act in Ontario. So in the Sale of Goods Act, it says under their Section 8, that if a contract is silent as to price, a reasonable price can be implied. Is this contract silent as to price? Elena says no with her head. Why is it not silent, Elena?
I shook my head. I keep forgetting that you can see me. I said no because the price was stated to be determined by the two parties. So from time to time. So that is a clear definition of how price can be founded in the contract. Is just because there is no price there doesn't mean it's not there.
So this isn't a situation where it says nothing. Because if it said nothing, the court could imply a term and they wouldn't be changing the intentions of the parties, right? There maybe have been no intention, maybe they're adding to them, but they're not changing the stated choices of the parties. In this case, it wasn't silent. It said, we will look at it from time to time. Well, the court says that's an agreement to agree. What's an agreement to agree? Stephanie?
It's an agreement between the parties to come to an understanding on a matter at a later date.
That's right. So it's when we say, exactly like here, we will agree to this issue later. Well, if you say that, but there's no criteria by which you'll determine that at a later date or no mechanism to determine it, then you haven't actually given enough terms in the contract so that we know at the outset how the content will be determined at that later date. We don't even know when the date is, right? And so an agreement to agree is unenforceable because it contains a formula that doesn't work. The formula is we will agree sometimes. Well, okay, but if you agreed sometimes, there'd be no problem, as they did in contract in the first year of the contract. But it doesn't do anything to help out, right? If there is disagreement. So an agreement to agree is unenforceable. It's too uncertain. It arises where the parties just agree, we will figure this out later, but they don't provide enough information, enough of a formula for us to know at the outset how it will be determined or who will determine it. Isabella?
Yeah, so my question was, if we can't, how is this different from an option? That's something that I couldn't quite wrap my mind around.
How is this scenario different from an option?
Like, how is the idea that you are agreeing to agree on something later different from an option where you're making a contract and that if this contract is performed, then that one happens automatically? Like,
okay, so it doesn't apply, it doesn't happen automatically. So this is part of the issue in Hillas. But when an option is an offer, right? And it becomes accepted when the other party accepts it. The question then, it's not the option that's the problem, it's how much content is given in that offer. If that offer doesn't provide, you know, for essential terms, it will fail. But it's not the fact that there's an offer for a later period of time, because they're not entering into agreement now saying we will do this in the future. They're saying you have the choice, offeree, to accept this in the future. These are the terms that would bind us if you accept. Does this answer?
Yes, thank you.
No problem. Okay, so the court says, well, we can't, you have an agreement to agree here. The contract's not silent. And they say, the thing here is, they say in the Sale of Goods Act, there's also a provision. So it doesn't, okay, stop. There's also a provision that addresses directly what happens if the mechanism fails, not the formula, but the mechanism, right? So it says, if you appoint a third-party valuator and the third-party valuator can't determine the content, your contract fails. Where Techmaster says, surely it's the same thing if you appoint a formula and the formula fails. An agreement to agree is a formula and it fails. And so, you know, if the statute and the common law principles tells us that if your machinery fails, the contract fails, then if you include a formula and the formula fails, the same outcome ensues. So in other words, when you say we agree, we will agree later, and you don't provide any content on how we're going to agree later, then you have an agreement to agree and it's unenforceable because it doesn't, because it creates a formula, but that formula doesn't work. And the courts can't just step in and fix your formula because they'd be changing what you decided. And what you decided is you guys wanted to determine this from time to time. But if the contract had been completely silent, the courts could step in and apply a reasonable price because they wouldn't be changing your intent. So the thing, one of the more fundamental things that to take from the case is when you're trying to figure out what principles should flow from the question of when can the courts step in and when can they not. So is have the parties spoken to the issue? If they spoken to the issue, the courts can't change their intention. But if they haven't, maybe the court can step in and help out. Okay. Elena, you had your hand up?
What would be an example of silence as a price? Because I feel like not mentioning price at all in a contract for like a sales of good contract would essentially be a missing term and then be void anyways.
So it is an interesting example because it's really weird to have a contract for the purchase and sale of something and have no price. Like, how can we say you've actually met a meeting of the minds if you don't do that? The type of scenario in which this tends to come up is where the parties have, like where there's true silence about it, is where the parties have had these kind of informal conversations about different bits of stuff. And one party's like, we've agreed. And the other one was like, no, we've just been in talks. Like, we haven't actually agreed to this. But the other part is the courts, if the courts feel that the rest of the agreement shows certainty and there was no discussion of price, the courts say, well, you must have just assumed that a reasonable price would be the one that would apply. And so the statute can apply it. But if another essential midterm was completely missing, that's not price, I'm not sure at common law the court could step in and create it. Because again, it would be so central that how can you say you've actually reached agreement? So like, if I'm buying a house from you and that contract doesn't stipulate what the house is, right? And for some reason, like, how do we, and we can't sort of figure out, maybe you have multiple properties or something. Like, well, how the court can't just step in and be like, oh, you meant that one, because maybe you didn't mean that one. So the point here is that ordinarily, if a really essential term is left out completely, it would be hard to say that the parties reached a meeting of the minds. But the court, because of the statute, the Sale of Goods Act, for sales of goods does not apply to other types of transactions that are not the sale of goods, like services or something like that. The statute allows for the implication of a reasonable price in those circumstances. Okay, so then the contract wasn't silent here, so no reasonable price can apply. The courts can't apply a reasonable price. They did have a formula, but it failed. And the courts can't fix the formula for them because that would be changing the terms the parties had agreed to. So why can't the issue just be resolved by the arbitrator? Because the courts appointed both a formula and a mechanism. So what's the problem with the arbitrator? Jay?
So the contract doesn't state that price is a matter that can be settled by arbitration. The clause is just a general clause regarding disputes that arise out of the agreement. And since this isn't a dispute, it's a failure to agree. And a dispute would only arise once you have entered into the agreement.
Yeah, so the court says the thing is that the way this arbitration clause was drafted says that it deals with issues that arise from or are in reference to the agreement. But there's no agreement unless all this essential terms are present. And so this arbitration clause would only kick in to deal with problems once the contract had been created, and it wasn't here. And therefore, the issue can't be resolved by the arbitrator. Questions about this analysis? Okay, so then how do we put all these pieces in order? So a court cannot create a contract if the parties have not done so for themselves. Again, the underlying idea is that the court's role is only to interpret and apply the choices of the parties themselves. And so they cannot change the terms in such a way as to change the intentions of the parties. If the parties are silent about an essential issue, in some cases, maybe the courts can step in because they wouldn't be changing the choices of the parties. On the other hand, if an essential term is completely missing, maybe there was no agreement at all. In either case, if the parties specify a formula that doesn't work, the contract fails. And if they specify a mechanism like arbitration and the mechanism fails, the contract fails. Okay. Yeah. An agreement to agree is defined in the contract or in the decision. It's an agreement that the parties will work something out at a later date that does not provide the actual criteria or formula by which that contact will be provided, or specify a mechanism or machinery by which it will be given contact. An agreement to agree in that sense is kind of both a formula and a mechanism, because it says we will decide. And so they are both formula and mechanism. And so it's a formula or mechanism that fails, and that's why an agreement to agree is unenforceable. Okay, a note on a decision called Sudbrook Trading. Genevieve?
Hi, sorry, Professor. Sorry to backtrack, but could you just please explain again why the arbitrator wouldn't work here? Like I don't feel 100% crystal clear on it.
Well, the idea here is there's the terms, the writing of the provision stated that the arbitrator's jurisdiction, the arbitrator was empowered to resolve disputes arising from the agreements or with reference to the agreement. So that suggests that the arbitrator can do things once an agreement has been created. But because an essential term was missing from the contract, no contract was ever created, and therefore the arbitrator never became empowered to do anything. That makes sense?
Yeah, that makes sense. Thank you.
I mean, of course, what flows from that is that you can try and draft your provision, your arbitration provision or your mechanism provision more broadly, and so that they would have the authority to address issues of uncertain or missing essential terms, right? Because this analysis was very much located in the way this provision was drafted. And so you could try and draft it in a broader sense. Okay, so there's a case called Sudbrook Trading. I haven't assigned it to you. You're just responsible for it for as much as I tell you right now. In 1983, which of course is very recent by contract law standards, the House of Lords made a decision in Sudbrook Trading versus Eggleton. It was a case that did not fall under the Sale of Goods Act. It was about the sale of property. And so the court in that instance said, you know, in May and Butcher, they say that if your mechanism breaks down, then the courts can't be the mechanism, right? And determine the content of the missing term. And that's because the Sale of Goods Act specifies it, and because more fundamentally, you'd be changing an essential term of the contract because the parties had agreed to what they wanted the machinery to be. But in Sudbrook, they say, you know, sometimes when the courts appoint machinery, like an individual, a group of individuals, an institution to decide something, they really care about the identity of who they've appointed. Like it really matters to them that it's someone who has a certain kind of training, like maybe it's somebody who is really good at accounting or has, you know, whatever, maybe it's some other kind of standard, right? So sometimes it really matters who we've appointed. But sometimes the parties actually just don't really care. They just want somebody to go in and figure it out. In other words, sometimes the machinery or the mechanism will be an essential term, and sometimes it won't. And so if the parties if there's nothing special about who they've appointed, then why can't the courts just be the machinery themselves, right? So say you appoint an arbitrator to fix any issues regarding essential terms in the creation of your contract. And you just pick like from a list of arbitrators, they have no special designations or whatever. There's nothing special about them. So why can't the courts just go ahead and apply the formula if one's there, or just fix the term if it's there? Again, if there was something special, if it was like we have appointed someone with special knowledge about stock options, I don't really know anything about a stock option, but somebody with very special qualifications, then the courts would be changing the party's intent if they acted as that machinery because they don't have that special qualification. But if not, then why shouldn't they be able to supply the mechanism? Okay, first, do you understand what that means? Second, how would we use that? Questions about what this actually means? Do you need to let it seep through your brain slowly? Elena?
So I think I get it. I think that the court themselves becomes the mechanism if there isn't like a specified requirement of the mechanism themselves, like an accountant or like an
There's
engineer.
nothing special about them. Yeah.
There's nothing special in that person. The court themselves can input themselves as the third party arbitrator.
Yeah.
I don't know. The second part of it was like how this applies. That part I'm slightly a bit confused because two conflicting cases.
Yeah. So sometimes there's two conflicting cases. But the idea here is the court says in Sudbrook, they're saying, okay, fine, under the Sale of Goods Act, the Sale of Goods Act says if your mechanism failed, the contract fails. So that's what it is. But at common law, if the issue you're dealing with isn't a sale of goods, then isn't it logical to say whether or not the court can step in depends on whether the mechanism itself is an essential term. And so there, what you're doing is trying to make an argument about kind of like what constitutes, like, why is it that the court shouldn't be able to step in or should be able to step in around the machinery? This doesn't work for a formula because the court wouldn't be providing the same service as the formula, but they are as the machinery. Is that making sense to people? Because the machinery is the process, the person who's going to decide. So the courts could be that person rather than the arbitrator if there's nothing special about the arbitrator. Right? Whereas the formula is the criteria. So if the court then changes the criteria, then they're changing what the parties decided. Elena?
Is it only applicable for sales of non-goods?
Yes.
Okay.
Because the argument in Sudbrook, again, didn't arise in that context. And the statute is straight up, like there's no arguing around what it says about for the sale of goods. If your machinery breaks, doesn't work, the contract fails. But what they're saying in Sudbrook is like, okay, but outside of that context, why shouldn't we be able to say that, in some cases, the machinery actually is not an essential term, so the courts can be it. And so what this does is provide arguments. So if one party is like, your machinery failed, so this contract is uncertain. The other parties say, yeah, usually, but Sudbrook suggests maybe we need to take a look at whether this machinery is actually essential or not. And if it's not, the courts could step in and fulfill that role. So all of everything we have on certainty of terms is just arguments, because we've got a set of principles and they don't quite contradict each other, but they're just deployed like contradictorily, if that makes sense. So it's all arguments for each side. Other questions about that piece, about this added piece? Okay, it's break time. So let it all wash over you. If you have questions that arise over the break, we can take them up when we come back. So come back at 3 and we'll go from there. Okay, let's get started back, friends. See how much farther we can get through our material for today. So May and Butcher set out kind of a whole lot of the principles that are used, particularly for missing terms, because that was the issue in that case. Although you can see where the line between vagueness and incompleteness can be hard to find, because in a situation like May and Butcher, I mean, there wasn't no price, right? There was nothing about price. What there was not enough. It wasn't ambiguous. It just wasn't enough, right? And so it can be a bit tricky sometimes to figure out the difference between ambiguity and vagueness and missing terms. Now, it doesn't really matter because the rules are the same, but what we'll see when we look now at Hillas, which has more issues about vagueness, is that some of the rules are more significant in the context of missing terms, and some of them are more significant in the context of vagueness, and some apply to everything, okay? Now that my cat came and rubbed everywhere, obviously I have cat hair in my eye. That's what happens. Okay, so our next case is Hillas and Arcos, and this case is can be a little bit hard to follow because there's kind of a lot going on, and it sometimes seems like they kind of the court addresses the same things a couple of different places, so it's a bit of sometimes a bit of a confusing judgment to make your way through. But effectively what happens here is that a company called Hillas, was an English timber firm, was in a contract in 1930 with the Russian government's timber wing. So they had a company called Arcos, and Arcos was the representative of the Russian government in their timber business, effectively. So in 1930, the two parties entered into a contract under which Hillas agreed to buy a certain amount of timber that was described as being of fair specification. In that initial contract, the 1930 contract, there was an option offer, right, which we remember is an irrevocable offer. And it specified that the buyers could, if they accepted the option, then they would create a contract with the sellers for the purchase of 100,000 standards that should be obtained for 5% less of the value than the official list price that Arcos prepared in 1931. In other words, Arcos, prepares a list of prices for all of its different timber, and they were going to pay 5% less than what the timber was being supplied to other people for. So the buyers did exercise the option, so they agreed to the option offer, which should give rise to this second contract for 1931. But when they did that, Arcos actually had, in the meantime, sold off its timber supply to a conglomerate of other English firms. And so they didn't want to be in a contract with Hillas anymore. And so they said that the option contract was too uncertain to be enforced. So they make three arguments about why this contract is not sufficiently enforceable. So the first one is that the option offer, which is in clause 9 of the initial contract, they said that was just an agreement to agree. And so the option offer was unenforceable. And if the court agreed with that, then there would have been no contract to decide on that would have dealt with the issue entirely. And they argued in the alternative, there were some missing price terms, such as the dates of delivery. And then there was some ambiguous terms, like how to fix the price and the description of the timber that Hillas was going to buy, because all it said was it was to be timber of fair specification. So what does fair specification mean? So Lord Wright takes these arguments in turn, but he starts off with some general principles. So he says that the document of May 1930, so the first contract that included the option offer, was very badly drafted. He said it was inartistic and repellent to the trained sense of a contract's draftsman. In other words, somebody practiced in the area would just be horrified at the way this contract was drafted. But he says, even if a contract is badly drafted, if it's clear that the parties intended to make a contract and thought that they had done so, we should try and give effect to that intention. So he said, businessmen often record the most important agreements in crude and summary fashion, modes of expression sufficient and clear to them in the course of their business, but which may appear to those unfamiliar far from complete or precise. He went on to say that it is therefore the duty of the court to construe such documents fairly and broadly without being too astute or subtle in finding defects, but on the contrary, the court should apply the old maxim of English law, which translates into words are to be understood so that the subject matter may be preserved rather than destroyed. What does that mean? The idea is if we can see that the parties intended to bind themselves to one another, but some of the contract was not super clear, okay? Still, we should do what we can to try and understand or to provide meaning to those missing or unclear terms so that the contract can be preserved rather than destroyed, right? So we should look to the terms of the contract to see whether we can figure out the missing or incomplete terms, what the parties intended about that. But the court goes on to say this does not mean that the court is to make a contract for the parties or go beyond the words they have used. What that means is go beyond the language of the contract. So in other places, you'll see it referred to as the courts must look to the four corners of the contract, which means what is written or what was agreed to between the parties rather than, their subjective feelings and views and all sorts of outside information. So the parties the courts can't make a contract for the parties, but if their intended meaning can be ascertained from the rest of the contract, it should be. Okay? So Viscount Dunedin had said the same thing in May and Butcher, but the actual application in May and Butcher was seemingly more strict. You would think that if you looked at the contract in May and Butcher and you were thinking of this, well, we should strive to preserve the contract rather than destroy it. Maybe we could have interpreted that arbitration clause in a slightly more generous fashion, and that would have allowed the contract to stand, right? But that's not what they did here. So the same principles were described, but they weren't applied in the same degree or in the same manner. So the court goes through each argument that's made about why the contract is too uncertain. And the first one is that the option is simply an agreement to agree. And I think it was Isabella who was referring, who had a question about this earlier. What they're trying to say is option contracts are all agreements to agree. Because what an option is we'll agree to enter into a contract in the future, right? And that looks like an agreement to agree from May and Butcher. And the court says, no, that's just not what an option is. An option is an offer. The parties have not agreed to enter into agreement later. One party has the option to enter into an agreement, to enter into the agreement later, right? And whether or not that option contract is sufficiently certain is not a matter of it being an option. It's a matter of the content of the offered terms in the option. Are they sufficiently certain? Do they include the necessary essential terms, right? So the difference between an option and an agreement to agree is that an option is an option offered. So sorry. When the parties come together and create a contract and there is an option within it, there is the possibility of a future contract, but the two parties have not definitely agreed that they will create another contract in the future. There is simply an offer to the other party that they can later come and accept the offer, and then there will be a binding contract. And like any other contract, whether or not it's certain depends on the offer that was accepted and its terms. Okay. Questions here. I think the easiest way to fully wrap your mind around this analysis is to sit down and be like, what is an option offer? Where is it? Why does it work this way, right? All the pieces, the integration type pieces. And when you do that, you'll be able to see that it's quite, an option contract is quite different from the concept of an agreement to agree. Okay. But this is a clever argument, one of those ones that you're like, well, it's semi-plausible, even though clearly wrong. So maybe they'll trick them and they'll realize and they'll agree with me, but no. Questions about this analysis? So it's not an agreement to agree. So now we have to say, okay, well, in the offer that was accepted, which is where the terms are the terms sufficiently certain? So one, they say, well, the price term isn't sufficiently certain. And the court says, no, like you have a formula and it looks like a working formula. The formula is, 5% less than the list price for the year. So what is Arcos's argument about why this isn't sufficiently certain? That's not a good one, but it's kind of funny. And for people on call who haven't participated a ton, what is the argument that Arcos makes here? Tyler?
Yeah, so I don't know if I'm confusing Arcos with Hillas, but because timber is a commodity that like fluctuates in price, that was the justification for it. But now that I'm thinking about it, I think that's Hillas. Is that right?
So we're not so much thinking right now about like why didn't they set the exact price, but like why does Arcos, like why does the Russian company say that the price list isn't sufficiently certain, or the price formula isn't sufficiently certain? They say, well, what if we don't create a list? Huh? Like, this is supposed to be based on this price list that we're going to create. What if we don't create it? Then how are we going to figure out the price? The court's like, yeah, but how are you going to do any business if you don't create your price list? If you don't have a price list, how are you going to sell anything at any price or do any business with anyone? Also, you've made a price list for the last like 10 years every year. Chances are you're going to make a price list. So it's not a very appealing argument, because the argument is, what if we don't do something? Like, what if we undermine this own formula, right? Which is not going to convince the court that you're particularly well-meaning here. If the price list was prepared by a third party and that third party didn't create a list, then there could be a problem, right? But the court says, practically speaking, you will need to create a price list to operate your business. So there's not going to be a problem with applying this formula. Okay. Then the third argument is the description of the goods to be purchased too vague? Can we figure out what is meant by timber of fair specification? How does the court approach answering this question? What do they try and figure out? Kyle?
I think they looked at like within the four corners of the contract, and they looked at clause 7, maybe, I think.
Yep.
And they kind of compared it to clause 9, and they said that like the goods were accurately described in that clause. I can't remember exactly what it said, but it mentioned it.
Yeah, that's right. What did they do? They looked at the rest of the terms of the contract to say, well, can we figure out what fair specification means? And there was in clause 7 some other language that did the work of describing what was going to be purchased. And so they were able to find meaning from the rest of the contract, and therefore that term wasn't sufficiently uncertain. And moreover, they mentioned you were able to figure out last year. So I don't know why it's going to be any different this year, right? Again, here you've got a situation where the party wants to just get out of the contract, right? And so they're like, oh, it was uncertain. Okay, well, that might work, but when you're like, it could be uncertain because we could not do things. The court's not maybe going to be that sympathetic to your cause. But what you see here is a couple of things. So mostly it's the court is looking at the rest of the terms of the contract to see if it can give meaning to the terms that were argued to be uncertain or too vague, right? And so the courts had said in both cases, if you can find meaning for the missing or vague term from the rest of the contract, you should do so. Okay. And then there won't be a certainty problem. But in May and Butcher, they applied that with a sort of, they were less generous in their interpretation of the arbitral clause, because they could have said, well, they could have interpreted it in a broader manner to support, to preserve the subject matter rather than destroy it, and they didn't. So that general principle that you should try and find meaning from the rest of the contract, that applies whether it's an incomplete term or a vague term, right? Your first step always is, can we figure out what is meant by this concept or what was intended about the missing term from the rest of the contract? If you can do that, there's no problem, right? If you can't do that, then the question is, can the courts fix the problem, whether the problem be a formula, total silence, or the mechanism, or some combination? And the answer to that depends on whether the contract was totally silent as to the issue, or whether what the court would be doing would be effectively changing the choices of what the parties themselves had made. So, 2 points. In Hillas, the court, is persuaded that the parties do really intend to contract. And there's kind of underlying just like characteristics of this deal that kind of push them in that direction. One, they think it's reasonable in the circumstances not to have stated the specific times and dates of delivery. Like there was a good kind of a reasonable kind of market idea for why you wouldn't specify them right at the outset. And so it would be logical and it wouldn't undermine the idea that they intended to contract. There was sort of there was part performance under the contract, not totally, because there were 2 separate contracts, although on similar terms. But there was sufficient performance under similar terms to suggest it's not impossible to figure out what needs to be done in this contract. And so these different aspects kind of push to the idea that the parties did intend to bind themselves. And so the court should strive to give effect to that, give effect to their intentions. Now, the courts have also recognized that where, so in both Hillas and May and Butcher, the parties had been in a contract for 1 year, and then we're creating a contract for the 2nd year. New contract. So, and the issues with the new contracts. But there are also cases where a contract has been performed under for some time, and then one party argues that it's too uncertain. And the courts have stated expressly that in those situations where there's been part performance under an existing contract for some time, they'll strive even harder to find a way to give meaning to vague or missing terms. So an example of this is a case called Foley versus Classic Coaches. And it's the 3rd in the kind of trilogy of May and Butcher Hillas and Foley and Classic. They're decided kind of each 1 year after the other. So just in brief, Classic owned a fleet of cars, and they purchased some land from Foley, and Foley also owned a gas station. And as part of the contract, Classic agreed that they would purchase all their gas for their fleet of cars and from Foley at a price to be agreed on by the parties from time to time, which looks like an exact agreement to agree, right? That looks very similar, almost identical to the wording in May and Butcher. After 3 years of Classic buying its gas from Foley, it decided that it could get it cheaper somewhere else. And so it stopped buying its gas from Foley. Foley sued for breach of contract, and Classic said the contract was uncertain. And the court enforced the contract, which again seems like a direct contradiction of May and Butcher. And what seemed to really motivate the court here was that, you know, the Classic buying the gas from Foley was a core part of what Foley was supposed to receive under this contract. They'd been doing it for 3 years by that point and hadn't had a problem. And clearly Classic just didn't want to live up to the agreement that it had created. And so even though, yes, like they didn't say this, but clearly this wasn't a well-expressed contract, it did lack a price term. The court nevertheless sort of strove to give meaning to the price term based on the practices between the parties to enforce this contract so that Foley wasn't deprived of the main thing they were supposed to get under the contract. The point of which is to say that if you have a fact scenario in which one of the parties has been performing, or both parties have been performing under the contract for some time, the courts will strive even further to find meaning and enforce the contract rather than declaring it void for uncertainty. But it's important to remember again that the courts cannot create a contract for the parties. So often I see on exams students being like, oh yeah, they'll fix it. They said like they'd try, so they will, right? It's really not that simple. There really is this weight between these two scenarios. But what you have in these cases are very similar facts with different outcomes and different rules prioritized amongst them. And what that means is that you have ways of building arguments and facts to analogize and distinguish from for both parties to almost any argument, right? When you have a certainty issue, there's almost always going to be an argument for both sides because they have these different, they'll have, you know, two cases with similar facts with different outcomes. So if you have similar facts, there's arguments to be made by both sides. Okay, questions at this stage. Okay. Have we reconciled the difference between May and Butcher and Hillas? Is there something or some things that distinguish them that we could use to explain, you know, why one was unenforced and the other wasn't? So in both cases, the parties had been under a contract for 1 year. They had performed despite the potential uncertainties. And then when they made the second contract, there was a certainty issue alleged. Very similar situations. Elena?
Can you hear me?
Mm-hmm.
So for both cases, they were arguing similar terms, like they were arguing for vagueness. However, with the Hillas case, the argument of vagueness, like the context was they were also like hindering themselves. So there was although it was vague in the contract themselves, they themselves were fulfilling those elements to the contract. So if they were vague and they didn't fulfill those elements to support the formulation of the contract, they were hindering themselves. So therefore the court would look sideways, not sideways. So they would look at that as like
sideways. Yeah, so you're basically, the idea is like, here they were arguing the contract was too uncertain because the problem with this formula would be they choose to undermine the formula. So that's not a great thing. So there was kind of a fairness question about asserting the terms of the contract. Although, of course, like kind of unfair also to May and Butcher in the first case, that all of a sudden this contract is not enforceable. But that is one difference. Kyle?
Oops. Maybe that one was, although they're kind of the same thing, one was an option and the other one was an agreement to agree. And then with the option, they were able to look within the four corners of the existing contract in order to kind of shell out and determine what the meaning of the vague and maybe essential terms were. Would that be?
Yeah, except the question is like, why couldn't we have done that in May and Butcher too? Like, why couldn't we have looked to the four corners of the contract and said, okay, this arbitration clause is broad enough to fix the issue, right? So it
Would
was
it
like,
maybe
Mhm.
would it maybe be key? Sorry, maybe because kind of that, like you couldn't infer from the contract in from May and Butcher the purchase price, but you could with the other.
Yeah, so what did they actually decide about was the price in Hillas? Like there was a formula and the formula worked, right?
Mhm.
So that's a big difference between the two, right? In one case, there's a formula, the formula worked. The arguments were not even really arguable that there was a problem with the formula. In the first case, the formula didn't work. And so if you can see in one contract, well, you know what, like you have agreed about price, right? And so that is probably the most essential term in the sale of goods. So probably you have reached agreement and we can find the meaning of these other things, right? Whereas in the first case, there really was no formula other than an agreement to agree. And so, and there weren't other things argued. If there had been other things that were argued to be unclear or vague, maybe we could have found them in the four corners of the contract, but it was just that one term that was being questioned. So arguably, you know, the fact that one had a workable formula and the other didn't, you know, could drive the outcome. On the other hand, it doesn't really resolve to me why the court couldn't have been a bit more generous in its reading of the arbitration clause. So there's some basis on which to distinguish, but you know, also ways in which the courts just decided which principles to use. All those principles in both cases are all there, but they used some and prioritized some in each of the cases. What about Foley Classic? Foley Classic and May and Butcher is like almost identical price term, right? But just complete opposition in the decision. Elena?
I think two main differences in the case that you would distinguish is one is the contract was carrying out for a long period of time, and it wasn't as if they were creating a new contract. It's just someone wanted to be void from their contract. They didn't want to continue on. They wanted to break their contract essentially, versus the other case where they were trying to create a new contract. And then the second one would be that the original agreement, the value or the thing that Foley was receiving was that he was going to pay gas at his gas station. So if he stopped paying gas at his gas station, then he no longer fulfilled that portion of his contract, which is the sizable value that Foley was supposed to receive.
Yes, although that's also true with the tenters. Like they're supposed to get the tent. They get nothing if they don't get the tent. I mean, yes, I think exactly the courts are motivated by the idea that the contract was ongoing and that it was really just like, you know, classic wanting to breach. But that's also true in, it seems to me, kind of a technicality that it's like, oh, it's at the beginning of the new contract. You're like, yeah, but they're on the same terms. yes, I think the fact that one was ongoing and one wasn't, in terms of the actual losses to the parties, I mean, it does kind of leave May and Butcher just out in the cold, right? But the fact that they were creating a new contract probably is what drove that decision. So if we're to take together all the principles we've learned with some of the things from the excerpts, the different cases that added in principles that I gave you as well, what we can say is at the broadest level, what we're trying to determine is whether to an objective bystander, we can say that the parties have reached agreement on all the essential terms, they're all present, and they are all sufficiently capable of being given a reasonable degree of certain meaning. We determine what constitutes an essential term by examining what is needed for the parties to understand what are their primary obligations under the contract, what terms are needed for a court to be able to determine whether a party is in breach and whether they would, and what loss they would suffer if there was a breach. For that reason, what constitutes an essential term changes based on the nature of the contract. We know that the courts can't make a bargain for the parties because their role is only to interpret and apply the terms that the parties have chosen for themselves. Nonetheless, if the real intention of the parties can be collected from the language within the four corners of the contract, the court must give effect to it, right? And so what we're trying to do is meet this tension between trying to discern the meaning from the rest of the contract and give effect to what seems like an intent to contract imperfectly expressed, and situations where, you know, even if you thought you contracted, I mean, you simply did not come to agreement on a sufficient number of the on the essential terms such that we can say that you've agreed to do the same things. So the first thing you're doing once a term is you're making an argument whether a term is uncertain or not. First of all, you kind of want to establish, like, is it uncertain, right? Maybe it's not, you know, like in the same way that, you know, the price formula was challenged in Hillas, but really there was no problem with it. Okay. Second, if there is a problem, can we find meaning from the rest of the contract? On an exam, I would not expect you to go into some detailed contract interpretation venture because you have not done that. Learned that yet. So I would provide facts that would make it sufficiently obvious for you to grab them. If it's not possible to give meaning to find meaning from the rest of the terms of the contract, then we get ourselves into the line of questioning from May and Butcher, which is, was there a workable formula? Was there a workable mechanism? And if either of them are not unworkable, can the court fix it in the instant in that circumstance? Okay. We know an agreement to agree is unenforceable because it's an unworkable formula. Also, just to add in at this point, sometimes you'll see language that says we agree to negotiate in the future about X term. An agreement to negotiate without more is just an agreement to agree and not enforceable. But in some instances, an agreement to negotiate in good faith can be enforced, but you don't have to learn that now. So I'll park that piece. We know that the Sale of Goods Act has a specific rule when it's a sale of goods contract. If the price is absent completely, a reasonable price can be inferred. It seems unlikely that applies to other missing terms, but it's arguable. And then if a non-essential term is missing or vague, that doesn't question the enforceability of the contract, and it can later be excised, removed from the contract, or treated as non-existent, and the rest of the contract will continue to proceed. Questions about this? So I have an exercise I don't think we have time to do it. Also, I think your brains may be like, no new information, but I'm just going to keep plowing on because I don't know what else to do. But I would recommend working on that exercise to help order these different principles in your mind and think about when you would use which one. Okay, so I'm going to move on to consideration unless last minute questions are percolating about certainty of terms. Kyle?
Yeah, I'm sorry. I thought I got it, but I don't. What's the difference again between an option contract and an agreement to disagree? Agreement to agree, sorry.
With an agreement to agree, you attempt to enter into contract now that's enforceable, but you say there's some part of this that we're going to work out in the future. Right? With an option contract, there's an option, there's an offer that exists in a contract. It's not a contract yet, right? That option, it's an offer. So it's not, the two parties are not agreeing that they will later get into a contract. There is an offer that a later date the other party can accept. And so it's not an agreement to agree later, it's an offer that can later be accepted.
Makes much more sense. Thank you.
Okay. Other questions or thoughts? You're just going to get more information. Okay. Okay, so that's the end of certainty of terms. It is one that's a little bit finicky, and so is worth trying to sit down and do the synthesis, the integration, practice the exercise to make sure it's all ordered in your brain. But now we're going to move on to consideration, and we're going to spend some time on consideration. And consideration is the third doctrine that the parties must, or that the party arguing a contract has been formed must present or must demonstrate for there to be a validly enforceable contract. So we'll spend the rest of today and next class looking at, just kind of what is consideration, wherein is it present or absent, and then we'll start looking at how does one change the terms of the contract, which is a question of consideration, okay? And that will lead us into the doctrine of promissory estoppel, and then we'll be done for this semester. Okay, so a little bit of background about the concept of consideration. Consideration, we've kind of mentioned at a bunch of different moments throughout the semester. And the doctrine of consideration answers the question within the Anglo common law tradition of what promises should be enforced by law or as a contract. So we make promises every day, right? Should they all be enforceable by the courts? Should I be able to go to court and say, like, you promised to buy my groceries? Like, that seems like a lot of resources for something that maybe wasn't so serious. How do we decide what types of promises and when should be enforced by the courts? In the common law tradition, it's the doctrine of consideration that has answered that question. Whether it has done so satisfactorily is another question. There are kind of long-standing points of like ongoing questions about what really is the purpose of consideration and do we really need it? But at the same time, those questions have been around kind of since consideration was first required, and we all kind of ignore it and keep going. Consideration continues to be one of the most central aspects of the common law of contracts, and the courts are notoriously hesitant to do very much or change much around the doctrine of consideration. So there is one way to make a promise. Okay, sorry, just to, I'm going to come back to this one in a minute. What is consideration, right? So there's a definition that's sometimes around by in a case called Curry and Misa, And I don't like that definition, FYI, because it has a piece in it that's no longer good law. And so I try not to use it and have you guys not use it lest you go astray with it. So the definition I find most useful is one by Frederick Pollock, again, one of those like British authors, that was adopted by the Supreme or the House of Lords there in Dunlop Tires, that we'll read a little probably next semester. And that definition is that consideration is an act or forbearance of one party or the promise thereof. And it is the price for which the promise of the other is bought. And the promise thus given for value is enforceable. That sounds like a whole lot of nothing until we break it up into its component parts. So what they're saying is I can give you an act, I can forbear from acting, or I can promise you that I will act or forbear from acting. And I am purchasing your promise to me by acting, not acting, promising you of my act. Each one of us is purchasing something from the other. We are each receiving something. So I can promise you, or I can ask that you give me an act, that you give me your agreement not to act, or that you make a promise about either of those things, right? The first two being with a unilateral offer and the second with a bilateral offer. And then I can make the same to you. So it might be easier to understand if we look at this little slide. Okay, first of all, where do we find this consideration? We find it in the offer that was properly accepted, in the same way that that's where we find the essential terms, because the offer sets out the main terms to which the two parties agree. So the person making the offer is usually the person who is making the most explicit promise. So if I say to you, I will wash your car if you do my groceries. This is an offer from me. And when you say, yes, you are accepting my offer, right? It's also a promise by me. I promise I will wash your car if you do my groceries. I've made you a unilateral offer. If you do the act of doing my groceries, I promise I will wash your car. My offer contains my promise to you and my request about what you will give in return to me. My promise to wash your car, I give it so as to get your act of purchasing the groceries. Okay? Each one of us is giving each other something. I'm giving you the promise that I'll wash your car, and you're giving me the act of doing my groceries. In this sense, consideration moves between us. What does that mean? All it means is that each of us receives something from the other. And the thing that we receive, we purchase by giving the promise or the act to the other. Questions, comments, repetitions? Laheen?
I guess I'm just a little bit confused as to how consideration as a promise, like the purchase of the promise that you mentioned, kind of differs from like offer and acceptance, if that makes sense.
Mm-hmm. So offer and acceptance is about figuring out, have we come to an agreement on terms, right? So have I made you an offer? Have you agreed to the content of my offer? Certainty of terms is about figuring out, okay, once you've accepted an offer, did it contain everything it needed to contain, right? In terms of essential terms. Consideration is, can we make sure that each party gets something? So as I mentioned earlier, when we were talking about revocation, a bare offer is not supported by consideration because both people aren't getting something. One person's giving something, but the other but they're not getting anything in return. But when you accept the offer, you should each be getting something for your promise. It's not so much that it's different. Well, it's that each of the concepts are doing slightly different things. And usually, if there's an offer and there's acceptance, both parties will receive consideration and there will be no issue. But once in a while, you'll see that actually you've made an offer, it's been accepted, the terms are sufficiently certain, except one party hasn't really bound itself to do anything. Let me give you an example. So I've posted some exercises for this week, and I'm just going to pull up the consideration ones. See if I can make this clearer. Okay, hold on. Okay. Okay. Okay, so if we look at these conversations and we're trying to figure out what is the consideration. I see Arshdeep, you have a question. I'll just come back to it in 1 second if that's okay. So in this scenario, A says to B, I'll pay you $5,000 for this car. B says, yeah, deal. What is the exchange? Isabella.
The exchange is the car for the money. So both car and money would be the consideration.
Yeah, so A is promising that they will give B $5,000. And B is promising that they will give the ownership of the car to A. Each one of them is getting something, right? Exchange, excellent. A says to B, I can help you study for exams. B says, great, that'd be amazing. I might be able to help you with your household chores sometimes too. What is the exchange? Tyler?
So I would say the exchange is the helping with the studying for exams in exchange for the household chores help. But the use of the word might, there's some uncertainty with that. So I don't know if that like lessens the degree of it or not.
Yeah, so the problem here is that A has definitely said they'll help B with the chores. B has not definitely said that they will help with chores. B has not bound themselves. And moreover, it doesn't look like A gave their promise to get something. It doesn't look like A was promising to help study with the exams to get help with the chores. So although each party looks like they're giving each other something, first, A doesn't look like they gave their promise so as to receive something in return. In that sense, they didn't give their promise to purchase something in return. And B has not actually bound themselves, made themselves obliged to do that thing so as to get the help with the exam study. Okay, so as Boutillier will take us, that might not constitute good consideration. But if you just looked at that exchange in the offer and you weren't thinking about it too hard, it might look okay. Right? Laheen, is any of this helping clarify your question?
Could I just quickly clarify that it's important for consideration that the party is like making the promise to get something out of it?
Yeah.
Like, to have somebody like reciprocate, for lack of a better word, is like a key part of consideration.
Yes, because the idea is that contracts are bargains. They're exchanges, right? So one is you're supposed to be giving something to get something. And that if you go back to that definition from Pollock, the price of my promise to you is your promise to me. And so one is it's important that you're giving something to get something, but more importantly, you have to bind yourself through your promise. It has to be that you are now obliged to do that thing to get the thing you've asked for. If you don't have it, well, if you, and this we'll talk about with the concept of an illusory promise. If I say, yeah, I might be able to help you with your chores, that means I'm allowed not to help you with your chores. Well, that means you might not get anything for your promise. And then we've got no exchange. You haven't received consideration from me. I haven't made myself obligated to you to do this thing. That's a consideration problem, okay? Scenario 3, A informs their employer, who is B, that they will be suing B for dismissing them from their job without sufficient notice of dismissal. The parties enter negotiation and B agrees to pay to a settlement. They'll pay 6 months notice. So A releases B from any future liabilities and legal aid claims related to employment with B. Okay, it's a bit of an engaged kind of scenario, but basically if you have a legal claim and then the parties settle the claim and one party creates a release. This is very standard thing to happen. So what is the exchange here? Stephanie?
B is promising to pay A for the 6 months, and then A is releasing B from further liabilities.
That's right. If you pay me 6 months, I will not sue you for anything else, right? Both parties getting good consideration. Okay, then let's look at Mr. Rogers, who's like even more my hated people this week than usual. I didn't even know that Ed Rogers was so terrible and also racist. But anyways, I hated them all already, so it's cool. Okay, so you know, in like your Rogers terms of service or Netflix or whatever, it'll often say, we reserve the right to change the terms at any time for any reasons. So I promise that I'm going to pay you for my services, but you promise you're going to change whatever you want whenever you want. That looks like a problem. You haven't bound yourself to do anything because you can change your mind. You're like, we promise to provide you services for 1 year unless we change our mind. Okay, then looks like I've given you something and not gotten anything. And if that's the case, there hasn't been an exchange. I haven't received consideration. And so we can't say that this is an enforceable contract. Similarly, A offers B a landscaping job to redo some work. And A says, the terms of the agreement is that if I'm satisfied with your work, I will pay you $8,000 as long as you can do the work by November 25th. So what's the exchange here? Stephanie, is that a new hand or?
Oh, sorry, that was still the old one.
Okay. So what's the exchange here? Or what's the potential problem with this exchange? Elena?
I think it's if she's satisfied with the work is the essential problem, because if she is not satisfied, there's going to be no exchange, there's going to be no consideration because she won't pay the $8,000 for the work that was being done. And then B is not getting any considerations in that offer.
That's right. She has unilateral discretion. If it says somewhere in the contract how her satisfaction will be determined, you know, maybe that's okay. But she has unilateral discretion to unbind her, to do nothing. Or Rogers may have unilateral discretion to do nothing. That is what we call illusory consideration. Okay, well, I'll set out the principle again for that next week. What the parties usually do is Rogers will bind themselves to some things, and then you'll get some consideration. Like, we promise we'll give you notice if we're going to change the terms unilaterally. And then because you got something, that's good enough for them to be able to change whatever they wanted to for the rest of the time. But the idea here, if we go back to our slides, is, oh, go back. Is to say that what we're doing is we're looking at the offer, and then we're saying, what has the offerer promised? And that's usually more visible because they've put together their proposal to you. So they're proposing, they do something to get something from you. So what are they giving and what are they asking for in return? Has each one been given so as to purchase the others? And are both people bound by this exchange? Do they have unilateral discretion to walk away if they want to? If they haven't bound themselves, they haven't committed themselves to providing something to the other party. Now, Archdeep had a question. Would we be able to always say that bilateral offers have a discernible consideration, whereas with unilateral, it's a little different? I'm not sure if these examples have answered that question, but no. In fact, if anything, it's often more clear what is the consideration with the unilateral offer, because it's the act that one party's promising to do something and the act that they're requesting in return is the consideration they're asking for. Right now, we're not concerned with whether the parties have done it, right? That will be a question about a breach if the contract is formed. Right now, we're asking themselves, have each party bound themselves to do something or agreed to do something in the offer that's properly accepted? Now, maybe what's a source of confusion here, Arshdeep, is that it's with a unilateral offer, you're not giving each other promises before the acts are undertaken. But because the contract is only formed once the performance act is undertaken, then the offerer is getting their thing at the time of acceptance, right? The act that they've requested, and then their promise kicks in and the other party gets something for their act. Does that answer the question? Okay. So the idea is each party's supposed to get something, and the thing they're offering, they're getting to buy some from something else. And the thing can be forbearance. It could be like, I promise I'll wash your groceries if you like stop calling me on Tuesdays, right? I'm asking you to forbear from doing or to promise to forbear from doing. That's fine too, right? Because that's something of value to each of us. Again, this takes us back to this idea that contracts are exchanges, they're bargains. And that then explains in further depth that idea of why an offer can be revoked before it's accepted. It's because before there's acceptance, only one party is giving something. The other party hasn't yet accepted to provide something in return. So both parties haven't received consideration until there's been an offer that's accepted. That's also why when you're answering a hypothetical fact pattern, you can't start telling me about consideration until you show me what is the offer that's been accepted, because where are you looking for your consideration until you know what is the offer that's been accepted. Okay. Now there was a moment, like you might remember when at the beginning of class when I was talking about the history of free will contracting that emerged in the mid 19th century, that there was a moment when it was suggested that we get rid of consideration, that we should say it doesn't matter whether there's an exchange, we should enforce promises, because promises, like fulfilling your promises, is a moral good. And so if a promise is made intentionally and intended to be binding, it doesn't matter if you get anything back, we should enforce that as contract. And the House of Lords debated this for a little bit and ultimately concluded that no, they stayed with the idea of consideration in Eastwood and Kenyon and said, we're not so concerned with your morality exactly, but we want there to be an exchange. Both parties need to get something. Well, okay, so we need there to be an exchange. Why? Not really clear, right? So Lon Fuller, I don't have this part on the slides. I have some of Lon Fuller's arguments. So Lon Fuller is, again, one of these big, this time American writers about contract. They're all white and they're all extremely old. And Lon Fuller argued two things. He said, one is, well, the reason we should enforce bargains is that exchanges are wealth creating, whereas a promise, a gift, just distributes wealth, right? If I just give something to you, I'm not creating new wealth, I'm just giving you some. Whereas if there's an exchange between us, it's more likely to be wealth creating. I mean, that could have been an argument, again, if the goal of contract law was wealth creation for some reason. But there's been pretty heavy critique of that idea that gifts are less likely to be wealth maximizing than exchanges. And so that has been a little bit as a justification, it's been kind of less accepted. The other reason he said as well, consideration has an evidentiary function, right? It shows to the court the seriousness of the exchange, because each party has to articulate what they're giving and getting. And in that way, they're really showing how much they want to be bound to one another, right? So if we need some criteria by which to determine which promises to enforce, if we require the contract to be a bargain, it again reinforces the evidence of the party's intent to be bound. It imposes a check on impulsiveness. You know, like my mom does this all the time. Ooh, I want to give you these things. Oh, maybe I don't want to give you those things, right? When you have to go through that process of creating an exchange, maybe you're less likely to sort of impulsively give things away and not be enforced by the courts. But even its evidentiary function is not that convincing, because by the time you show there's offer and acceptance and certainty of shown, surely you've demonstrated by that point that the parties intended to contract, right? Like you've already gone through two big doctrines. Why do we need a third? The answer is I do not know. I think that, again, it's some idea about contracts as wealth maximizing, and that exchanges are more like market-based activities than gifts. I'm not sure that's really empirically correct, but I think that's probably part of the idea. So that leaves us with the idea that I'm not sure there is a super persuasive argument about why we need consideration. But at this point, it's so old that the courts get very nervous about doing anything about it. And we'll encounter this more later on in the semester. But when it comes to the common law, right, the common law is judge-made law. But the courts will say, even with judge-made law, they should only be making incremental changes, smallish changes to the common law. If there is a common law principle that is really old or has been really important, even if they created it, we should leave it to the legislature to make statutory changes. Like if you say, please get rid of consideration, the court would be like, whoa, that's way beyond, that's not an incremental change, right? The government should do that if they want to. It's so old. Now we'll see that, I don't know, they've been getting a little creative recently, but again, consideration is viewed as kind of the hallmark of the common law system. It's not required in the civil law system and in other legal systems, but it is in the common law. The courts will say that consideration must be of value, but it need not be adequate. That is not self-explanatory. The idea is that the courts don't investigate the fairness of the exchange, right? Again, in the same way that the job of the courts is simply to interpret and apply the choices of the parties. If you want to make a super unequal bargain, you can make a super unequal bargain. That is not our job, right? If you want to sell your house for $2, you can sell your house for $2. You chose that, it's cool. My caveat issue there is like, yes, if you're of equal power and you decide on that exchange, excellent. But in lots of times, we are not of equal power. And so my consent is simply, I really, really need this. And so I will accept your shitty terms, right? Okay. Anyways, the courts won't investigate the adequacy of the consideration, which leads rise to what's sometimes called the peppercorn theory of consideration, which is, I could give you a peppercorn as consideration, which doesn't have any financial value, but so long as each of us has gotten something that they want from the other, that's good enough to be good consideration. So each party has to receive something they value. Each party has to get something for their promise, but it doesn't have to be of equal value. Okay, it can be something very nominal. And in fact, when you make an exchange, which is wildly disproportionate, and one party is clearly providing a nominal price, meaning a very small one, $1, $5, the courts take that even more seriously because they see, oh, you have gone through the process of determining some tiny little thing that you'll get to make this enforceable. Any questions so far? Okay. So there is a way to make a contract in which only one party is getting consideration, and that is to make a contract under seal. So you get to have this nice little Weasley family seal. The idea is that to make an agreement enforceable, contract enforceable, in which is a gift, which is only one party giving something, the agreement has to be in writing. It has to include the words sign, seal, and delivered, and those three things have to happen. The parties have to sign, the contract has to be sealed. Most of us don't actually have our personal family seals like in the olden days. But instead you attach just like a gummed wafer, you just like lick it and stick it on the contract, right? And then it's delivered to both parties. And that will make a contract be under seal. And if the contract is under seal, then only one party will be receiving something for it. Okay. Questions, feelings, views, concerns? Estella?
So, what would be the benefit of being on the other end of a sealed contract, like the gifting end, I guess?
Well, sometimes we want to give gifts and we want it to be enforceable by a court of law. So there are property mechanisms to do that. You can put things in trust. You can create, inter vivos exchanges. You can give a will. But if you want it to be an enforceable gift, not through a property mechanism, then you can make a contract under seal. Like maybe I want to give you this house. I mean, I don't, but in case I did, I could do it this way. We would just make this agreement. It would be a little less requirement than some of the property law mechanisms that could permit for that. Does that answer?
Yes, thank you.
Elena?
Would this apply for like donating to charity? So, or claiming to donate for charity? Like, and I know we're going to do the case later. So,
I mean, there's 5 minutes. I can rush through it, but I don't think you want me to. So yeah, if you want to make a donation enforceable, and hi, hospitals and universities who should know better and have legal representation, put it under seal, right? Then you have no problem. Yes, if you want to make an enforceable contract in which only one party is getting something, then you can put it under seal. Otherwise, there needs to be an exchange. And to pull things together, again, the offer that's accepted contains all the essential terms that you're looking for, right? To see if they're there and to see whether they are sufficiently clear. And it also contains the consideration that's agreed to be moved between the parties. Now, usually the offer stipulates both what the offerer is giving and what it wants to get in return. So rather than someone sitting there and being like, I will give you my house, you will give me something in return, right? Because we don't speak that way. The offer will usually contain all of it. And so usually it's relatively clear what the offerer is giving. But sometimes there are questions about what they get in return. And sometimes the language used makes it look like both people are getting something, but when you look more closely, they're not. Okay. So we'll return to the question. We'll return to Boutillier not next week, but the week after. And we'll look at some other kind of consideration problems, like if the consideration is a gift to a third party, is that okay? And what happens when you are obligated under one contract to do something? If you enter into a contract with someone else to do the same thing, is that okay? Is that fresh consideration? So we'll look at some of these little scenarios next class, and then after that, we'll start looking at variations of contracts and consideration. So I wish you best of luck with your assignment this week with WLPS week. I hope that there's somewhere in there for a little bit of respite. I will not be having office hours next week, but I will be here when we come back if you need me. So take good care, everybody. Laheen?
Thank you for re-explaining the consideration. I was reading, I think, the Curry and Misa definition, and it was so confusing to me.
The reason why that I don't like that definition is it says a party has to receive a like disbenefit,
Mhm.
and that's not true anymore. Like it's not, you don't have to lose, right?
Yeah.
Both of you can win, which is why I didn't like that one. I took that
Yeah,
one.
I was so confused as to why that was the case. I do have a quick question, something that I've been thinking about this week.
Mhm.
And I know we didn't get to covering the Marquis case,
Mhm.
the Brantford case, but I remember towards the end it was saying that there was no consideration for Marquis because she was never really concerned with her name being on the wing. And I was wondering if, because her late husband's name is already on the wing,
Mhm.
I was wondering if well, now that I'm thinking about it, it doesn't make sense, but if consideration could have been his name being extended to the like combination ICU, because that was one thing that she said she was pretty concerned about.
I think the thing is with everything there is it's not that there weren't any benefits that could be given to her, but it's that the money wasn't given to get any of those things. Like she was clearly
Oh,
a gift, right? She wasn't trying to purchase anything returned. She was trying to give a gift.
okay, that makes sense. So then does that mean that in sort of all cases where it's just trying to give a gift, there's no consideration for the person giving the gift?
Yeah, because when you're giving a gift, you're not giving it to get something.
Okay.
So if I'm like, you know what, like with that example, okay, well, I'll help you study. Okay, great. Well, I'll help you with your chores. We're each just giving each other things because we want to. We're not trying to get it from each other. And so in that sense, we haven't made an exchange, right? So sometimes the court will kind of strain to try and find that to be enforceable because like one person will get something and the other one won't. But if I'm giving it to you as a gift, I'm not looking for something back. So if you don't give me something back, that's not why I got it. I gave it, right? So if you, and moreover, because she didn't, like because it was a gift, she didn't ask for anything specific in return. Like they didn't bind themselves to do anything in return for her gift. Again, there are times where the fairness of the situation will motivate the court to like find that to be an exchange, even if it was a gift. But otherwise, you know, again, it's not like this is like a tiny little institution with no lawyers. They should know this rule's been around a while. Put it under seal for goodness sakes, right? And so she made a gift. And it's the same thing with Mr. Boutillier. Like he gave a gift. He didn't say, I want to get these things back. And they didn't promise they'd do those things in return.
Okay, makes sense. Thank you so
Okay.
much.
You're welcome. Take care. Have a good few week and a half. Yeah. Take care.
Bye.
Bye. I'm leaving now, but good luck, Sarah.
Oh, Professor, are you there for 1 minute?
Sure.
Okay, I have a question.
Sure.
So my question is with an example that you gave in class. You
Mhm.
were talking about how, oh my gosh, I should have written it down. Okay, I can give you an example that I was thinking of.
Yep.
Would the court ever be mandated to like uphold a contract based on like behavior? I think the example you gave is like with the parent and like giving gifts to a child. So then like the child was like, oh, now I'll use these like toys better, I'll take care of them better. But then if the reverse was, oh, like I'll act better for my parents, like I'll be kinder now. Could
Mhm.
that ever, or could that ever be mandated?
Like, do you mean
Even
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 if
if it's not in a family situation?
like actions instead of promises?
Yes.
Yeah, so an action, as you know, can be what's requested with a unilateral offer. So the receipt of an action can be good consideration. So if I say, like, I'm not sure what the distinction you're drawing is. So consideration can be anything of value. So it can be the promise to act, it can be an act, it can be promising not to act.
That's such an easy example. Okay, thank you.
Yeah.
Okay, I think I was
Yeah.
just blurring. Thank you.
No, that's right. So that's what you're supposed to do, right? Try and think out the different permutations. So for sure. So I could say to you, like, I'll give you my house in exchange for a hug, right? So then we might be like, so the court might be like, I don't know, that's not even a peppercorn, right? But they might say, that's fine, that's what you wanted. And so as long as each of us are giving something to get something, I mean, the hug example, probably the court would say no. They'd be like, just go ahead and put in $1 in the stupid contract, you know?
Mhm.
But there's no problem that it be an act versus money, for instance.
Okay, thank you.
Yeah, no problem. Take care.
Bye.
Bye.